Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney that does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about whether or not your will or revocable living trust is forward-thinking enough. I offer free strategy sessions to potential clients where I review an estate plan that they may have in place already to determine whether or not it meets their desires and needs at this time. And I had a potential client come in with her father's estate plan. She was the agent under a durable power of attorney for her father. He has a terminal diagnosis, and she was just trying to be proactive to determine if there was anything she needed to do and then make sure that everything was in place and for her father should he pass, which was anticipated in the coming months. And when we were talking about her family's needs and who, the nature of the people that were the beneficiaries, it was mentioned that one of the siblings is disabled and that they're receiving disability benefits. And what caused me concern was that the revocable living trust and the will that her father had currently in place did not have any provisions for a testamentary supplemental needs trust, which would protect her siblings' inheritance and protected their ability to continue to receive the government assistance that they receive due to their disability. So we were able to talk through what that is, and essentially what a testamentary special needs trust is: a trust that would spring to life upon the death, in this case of her father, rather than this sibling getting their inheritance outright like the other siblings. This sibling's inheritance would be put into a trust for their benefit to supplement the government assistance that they need, but not to supplant it. So it wouldn't be monies that could kick them off of the medical assistance that they really need and might not otherwise be able to afford due to their disability. While their inheritance would be wonderful, it most likely is not large enough to be something that could completely replace their government assistance for the rest of their lifetime. So rather than putting their medical assistance at risk, the monies would be put into a trust, and the trustee then would be able to help supplement this sibling's lifestyle and his needs, and therefore his inheritance would not cause him grief. So we were able to put father on the phone and talk that out as well, and we're going to be able to help that family while there's still an opportunity to just enhance the estate plan and basically keep everything. The legacy goals are the same, but we want to put in that added protection so that specific adult child would not find themselves in a precarious situation once their father passes away. So while I do not believe that every estate plan needs to be all the bells and whistles and that simple is a good thing, I do encourage people to also ensure that you're forward thinking enough in your estate plan that you include this testamentary supplemental needs provision that would spring to life should one of your beneficiaries require it. So even though you think that none of your beneficiaries are disabled or have any problems at the time that you put your estate plan in place, you might want to make sure that it includes this provision, because you never know in the future. Your relative could have a car accident or some workplace injury that leaves them really severely injured and disabled, where they would then qualify for government medical benefits and disability benefits, and you wouldn't want your inheritance for them to cause them more problems than maybe that they anticipated. If this information has been helpful to you, I ask that you like and share. If you want to learn more about it, I encourage you to reach out to myself or an elder law attorney to be able to further this conversation. Again, I thank you for joining me.